call the meeting of the Planning Commission to order for meeting of April 24th, 2019. We have a roll call, and please.
Chairperson Sattler. Vice Chair Borders.
Here.
Commissioner Dors.
Here.
Commissioner Aswine. Here. Commissioner Preston. Here. Commissioner Tingle. Here. Commissioner Wiggins.
Here.
A quorum's present.
Thank you. Commissioner Tingle, would you lead us in the pledge, please? Public comment. The public is invited at this time to comment on and discuss any topic that is relevant to or within the authority of the Planning Commission, including any matters that is not specifically included in the agenda as an action item. Is there any public comment at this time? Seeing none, for possible approval, discussion and approval of minutes, any corrections? Hope you pointed one out.
Yes, I do have a correction on public comment, or not public comment, on page 8 of the minutes. Commissioner Tingle expressed concern about the water table in the standing war. I'm pretty sure that's supposed to be standing water, but just speculating. Okay.
Any other changes or
I have one.
Commissioner Eswine?
I just want to clarify. On page 5, under item E3, it says Commissioner Eswine was informed that the fire marshal had consulted with the state fire marshal. I don't recall being the person who asked that question. I think it might have been somebody else.
Any other changes or?
I move to accept the minutes as amended. Commissioner Dors, for the record.
We have a motion, we have a second.
I'll second it.
Okay, all in favor? Aye. Thank you. Excuse me. Items on the agenda may be taken out of order. The public body may combine 2 or more agenda items for consideration, and the public body may remove an item from the agenda or delay discussion relating to an item on the agenda at any time. Is there any modifications or changes, Lee?
No, sir, no modifications.
Thank you. All right, meeting items. E1, SUP-17-084 for possible action. Discussion and possible action regarding a request to modify an existing special use permit, SUP-17-084, to allow for the expansion of existing daycare facility located at 2321 North Carson Street, APN 002-061-34. Heather?
Thank you. Heather Ferris, Associate Planner for the record. The subject property is at the northeast corner of North Carson Street and Hot Springs Road. It should look familiar to most of you since you just saw this a couple months ago for a zoning map amendment, and it was recently approved by the board. A portion of the property was changed from retail commercial to general commercial. There are 3 buildings on the property. Jimmy John's and Denny's are along the North Carson frontage, and the multi-tenant building is located in the northeast portion of the property. The 2 restaurants are located in the area zoned retail commercial, and the multi-tenant building is in the area now zoned general commercial. The existing child care facility is located in the 2 westernmost suites of the multi-tenant building. Child care facility is a conditional use in the general commercial zoning district and therefore requires a special use permit. The expansion or modification of such a use requires the same approvals as the original permit. In 2017, the Planning Commission approved a special use permit for the existing child care facility. That's outlined here in orange. The facility is approximately 3,681 square feet in size with an outdoor play area and serves a maximum of 69 children. The applicant is seeking approval to expand into the neighboring tenant space, which is shown in red, increasing the total square footage to 4,981 square feet and increasing the total number of children to 89. There would also be a small expansion of the play area to accommodate the increase in children, and the exact number of children will be subject to state approvals. There's no proposed change in the loading and unloading area, which is located in the rear of the building. Parking for the various uses is located primarily in the south and west of the building, with 25 parking spaces in the rear. Parking is required to be provided at a ratio of 1 space for every employee, plus a dedicated loading and unloading area. The number of employees is a derivative of the number of children, but it is anticipated that there would be 3 new employees for a total of 16. Therefore, the parking demand would still remain less than the typical retail use. Parking was determined to be adequate in 2017 and is anticipated to continue to be adequate. I would also note that the expansion of the outdoor area would not result in a decrease in parking. In order to approve a special use permit, the Planning Commission must make 7 findings of fact in the affirmative. As outlined in the staff report, staff was able to make all 7 findings and is recommending approval, subject to the conditions and findings in the staff report. The applicant, Athena Hardiman, is here, and with that, I'm available for questions.
I just had one, I meant, under the conditions of approval, number 6 through 10 were removed, no longer. Is that, were those the original conditions and they have changed, or?
So those are original conditions, and after reviewing them, we determined that those are really, they're code provisions. And so they've been stricken from the conditions because they're required whether they're conditions or not.
They're covered by code, is the.
Correct.
Thank you. I just wanted to clarify that. Any other questions for staff, Commissioner?
The doors that face the outside parking lot, which are not now being used to deliver children, are they set up like emergency doors? Are they locked? Are they closed? How, I'd like the idea of the fact that they're using that one entry in the rear for all the children, so we don't have to worry about the parking lot. But I'm wondering if somebody comes in late and beats on the door, if somebody opens it and they come in, or is that prevented them from doing that?
So at this point, I would defer that question to the applicant.
All right. And the other question I have is it looks like the dumpster area is going to remain there and that the play area is going to expand behind it. Is that correct?
Correct. The
That last little
dumpster
piece over
area would
there.
actually be moved out a bit from the current location, which is in the northwest corner there where the play area is. So it would be pushed out so it would be accessible.
Okay, so the play area would be behind it.
Correct.
Then, in other words. Okay.
Correct.
Thank you.
Questions for the staff? Mr. Tingle?
Just a clarification, the loading and unloading area, is that the unpaved dirt?
No, this is the area in the rear that is paved. You go back to the aerial, directly behind the building.
In between the welfare division and that piece of property?
Yes, so it's in the rear parking lot, directly behind the subject building.
Any other questions for staff? Not with the applicant, come forward, please. State your name for the record, if you would, please.
I'm Athena Hardiman.
Push the button.
There you go.
I'm Athena Hardiman.
First of all, do you accept the conditions of approval as stated?
Yes, I do.
Okay. And was there anything you would like to add to her presentation, or?
Oh, okay. Thank you. I have no questions or problems with any of the conditions, and thank you for seeing us first. We have a flight to catch, so that was fantastic. Thank you.
That worked out. Any questions for the applicant?
Would you clarify my earlier question that I had asked staff about the entryways on the other side of the building?
So the rear entrance for the daycare right now is currently inside of the playground. And there's a double playground gate to, slow down adventurous children if they're able to get the first gate open. Inside of our double gated playground is the entrance to the building, and we have a coded doorknob on that right now. So all of our clients are given access code. So basically, they're able to use it freely. In the evening, we lock the gate so that no one can get into the playground.
My question is the other side of the building.
The front side of the building?
Yes.
So for the front side of the building, currently, only our clients who have infants in car seats use that for loading and unloading. And it's just because it's really inconvenient for a working parent to carry a diaper bag and a car seat and their baby all inside for drop-off. So currently, we're licensed for 8 infants out of the 69 children. So it's used basically for 8 families.
In the new section, the doors going out from that, are they used as well, or is there double entry into the old section? Will they come through that first to get to the new, or how is that going to work?
They will basically come in through the back. Putting another door in the back of the building is really cost prohibitive because it's a brick building, so it'd have to be all reinforced and stuff. We're fine for fire egress, just adding a door to the front. But so clients will use our back current entry and go through the daycare.
My concern was fire egress, and that's been
Yep.
addressed.
Yeah, that's our concern too. It's one of our big bottlenecks.
Any other questions for the applicant? Thank you.
Thank you.
I will bring it back for further discussion or a motion.
I'll go ahead and make a motion.
Commissioner Tingle.
I move to approve SUP-17-084-1, a modification to an existing special use permit based on the findings and subject to the conditions of approval contained in the staff report.
Sorry. I have it written down right here and already missed it. Is there any other public comment on this item before we go to a motion? Seeing none? Okay. Thank you.
Okay. Again? I move to approve SUP-17-084-1, a modification to an existing special use permit based on the findings and subject to the conditions of approval contained in the staff report.
We have a motion, and I will gladly second that motion. Commissioner Sattler? All in favor? Aye. Opposed? None? Good luck. Thank you very much. Thank you. No opposed. Thank you. We should be able to catch our fight. Moving on. E2 AB-18-157 for possible action, discussion and possible action regarding request for an abandonment of public right-of-way on specifically 4 areas. The easterly 3 feet on Voltaire Street and the area north of West Willow Street and south of West Overland Street. The southerly 8 feet on West Overland Street between Voltaire Street and Cochise Street. The westerly 3 feet on Cochise Street and the area north of West Willow Street and West Overland Street, and all of the 63 feet of right-of-way on West Willow Street between Voltaire Street and Cochise Street being 44,187 square feet, more or less, adjacent to properties located at 4539 Voltaire Street, 4580 Cochise Street, 4530 Cochise Street, 449 Willow Street, and West Willow Street at Cochise Street, APN 009-26501, 009-26502, 009-26503, 009-26706, and 009-26707. Thank you, Kathy.
Hope Sullivan, Planning Manager. Heather had one that she thought might look familiar, and this one might look familiar as well. On March 27th, the Planning Commission issued a special use permit for multifamily development in this area. The road right-of-ways that the chair identified in reading the title of the project are on this graphic. Just real quick, the applicant's seeking to abandon all of Willow Street from Cochise to Voltaire, an 8-foot section on the south side of Overland, a 3-foot section on the west side of Cochise from Willow to Overland, and a 3-foot section on the east side of Voltaire from Willow to Overland, so essentially along the perimeter of the properties. As part of the approval, the Planning Commission requested that the roadway improvements along Cochise, Overland, and Voltaire. The special use permit relied on on-street parking on Overland. I do want to note that property to the north of Overland, Clearview Ridge Planned Unit Development, was approved in 2006, and as part of that approval, that project also relied on parking on Overland. However, in 2006, the street standard for parking on both sides of the street was 50 feet. That standard is now 58 feet. So the applicant was anticipating that the standard would continue to be 50 feet and requested abandonment of 8 feet, anticipating that the city would only need a 50-foot right-of-way. The city does need a 58-foot right-of-way, so the staff is recommending that the portion of Overland not be abandoned and that the city retain that portion of right-of-way. The Board of Supervisors is authorized to approve an abandonment of right-of-way. The Planning Commission conducts a public hearing and makes a recommendation to the Board of Supervisors based on 7 required findings of fact. Provided that no portion of Overland is abandoned and provided that the NV Energy easement remain in place, the staff can make those findings in the affirmative. I do want to suggest a modification to condition number 5. In preparing for this meeting, I realized the second sentence of condition 5 doesn't make sense. What it says is that they cannot, the abandonment wouldn't be in effect until the abandonment of the NV Energy easement. What we'll do is in the order of abandonment, if the Planning Commission and the board agree, is we'll retain the NV Energy easement. So you can record an order of abandonment and retain an easement. And then at some future date, when they anticipate they're going to demolish the house, which is the beneficiary of that easement. So when that occurs, they can then get a notice of relinquishment from NV Energy and record that at a later date. But NV Energy's easement would not, our recommendation is that NV Energy's easement is not abandoned as part of this request. Steve Doncho, who's a property owner, is present, and again, with those are our main conditions. With those conditions, we can make the findings in the affirmative, and I'm happy to answer questions.
So Hope, why would we modify the wording then on 5? We would just remove the second sentence?
Correct.
Questions for staff?
I'm looking at
Commissioner
the abandonment plat. On Voltaire Street, it shows that at the southern end of it, it's a 66-foot right-of-way. And then it shows 60 feet adjacent to the property. Is the 60 feet what will remain?
Yes, on the plat, we'll continue to yield a 60-foot right-of-way. And so that's what you're seeing is the resulting street section as opposed, for example, if you look at Overland, you'll see they call out 2 25-foot sections because they were anticipating a 50-foot right-of-way. So when you do look at that plat, you'll see they have a dashed line. It's actually, I've asked them to revise this exhibit because it's a bit difficult to read the 3-foot sections of abandonment because it's such a narrow sliver. So I want that clarified prior to recordation. But yeah, we would yield a 60-foot right-of-way along Voltaire.
Okay, that's what I was wondering. Thank you.
Other questions for staff? If not, would the applicant come forward, please? Sir, welcome.
Hello, Steve Doncho for the record.
Yes, sir. First of all, do you accept the conditions of approval as written?
Yes.
Okay. Anything you'd like to add to Hope's presentation, or?
No, just that Hope's done a great job through this process. I want to make that known Appreciate it.
Any questions for the applicant?
And you have no problem with taking out the 8-foot abandonment?
No,
Thank you.
it's all going to work, hopefully. According to hope, it's all going to work.
Any other questions for the applicant? Seeing none, thank you, sir.
All right, thank you.
Is there any public comment on this item? If so, I'd like to come forward at this point. Seeing none, bring it back for discussion or a motion.
Mr. Chair. I move to recommend that the Board of Supervisors approve AB-18-157, an abandonment of only 3 of the 4 requested public right-of-way areas, removing the overland street from the request based on the 7 findings and subject to the conditions of approval contained in the staff report as modified.
We have a motion, do we have a second?
As modifying number 5.
I second that.
We have a motion and a second, all in favor? Aye. Opposed? Seeing none? Thank you, sir. Moving on. E3, SUP-19-030 for possible action, discussion and possible action regarding a special use permit to continue the use of an existing off-premises billboard sign located in general commercial GC zoning at 2794 Highway 50 East, APN 008-161-07.
The subject billboard was approved by the Board of Supervisors in 2006. It's located on the north side of Highway 50 in front of Centro Market. Per 4.8.3A2 of the development standards, a special use permit issued for a billboard expires automatically 5 years from the date of issuance. The applicant is seeking to renew the special use permit. The subject sign does meet the existing standards. When you consider a special use permit, you're looking at 7 required findings of fact. Staff was able to make these findings of fact in the affirmative, and we are recommending approval. Jason Ripp of Stott Outdoor Advertising is present, and I'm happy to go more in depth on anything if the commission would like.
Thank you. Any questions for staff? Seeing none, would the applicant come forward, please?
Hi, Jason Ripp with Stott Outdoor Advertising.
And you accept the 8 conditions of approval that are presented by the staff?
Yes, we do.
Anything you would like to add as a presentation or whatever?
We very much value doing business in Carson City, and we look forward to doing so in the future.
Great, thank you, sir. Any questions for the applicant? Seeing none, thank you. Public comment on this item? Seeing none, we'll bring it back for a motion or just further discussion or a motion. Mr. Tingle?
I move to approve SUP-19-030 based on the findings and subject to the conditions of approval contained in the staff report.
I'll second.
And a second, all in favor? Aye. Any opposed? Seeing none? That carries. Thank you, sir. Moving on, E4, MISC-19-047 for possible action, discussion and possible action requesting that the director investigate the conduct of Brunswick Canyon Materials LLC relative to special use permit U-79-25 located at 7400 Brunswick Canyon Road, APN 008-531-44 and 008-531-45. Hope?
Thank you, Mr. Chair. Hope Sullivan, Planning Manager. This special use permit was issued in 1979 for a concrete batch plant, a hot plant operation, and to remove earth products on the subject property. The special use permit included a condition that said, in part, public recreation access through the subject property on defined roadways must not be restricted. There have been a number of times that access has been restricted relatively recently, and I've outlined that in the staff report. The road, I need to go to my next page, sorry. The road, actually, if you were able to drive on it, you'll see, as soon as you turn in off Deer Run Road, you'll see a gate. That gate cannot restrict public access. If you drive down Brunswick Road and you have the Carson River on your right and you have a hillside on the left, once you get past the Brunswick Canyons, or Brunswick Materials facility, you are at the Carson River Canyon open space, which is an 870-acre open space owned by Carson City. When the public access is restricted, access to that open space is restricted, which I suspect is why this condition was put in there. What you have before you today is the first step in a revocation process. We do not want to revoke this special use permit, but we need to pursue this process while we work in parallel with the property or the business owner to try to accomplish compliance, because we cannot have the public access restricted. That is a violation of the special use permit. So I do recommend that the commission direct the community development, or request the community development director to investigate this situation. We would then come back to you next month with the outcome of that investigation.
Hope I just drove out there yesterday, and how and when and why was that gate allowed to be put up? Just
Again,
for clarification.
understood. And I failed to mention, Jen Budge, our Parks and Rec Director, is present and available to answer questions. In terms of when the gate went up, why it went up, so on and so forth, I'm not right now in a position to answer all those questions. We haven't conducted the investigation. Those are some of the things we'll look at when we do the investigation and report back to you on the outcome of the investigation. We have enough here to ask you to direct us, or request, you don't direct, you request, that we conduct the investigation, and then next month I should have more information.
And obviously, I'm guessing Canyon Material probably owns the gate, since he owns it. We don't know that either as well. Okay. Thank you. Questions for staff? Commissioner Doris.
Commissioner Doors, for the record, so the gate we're talking, that big rusty steel, the big one, the one that closes and opens automatically, we don't know who put that up?
I think there are people who know. I've heard about it. I have not validated, so I'm not prepared to report out on that, but I will be prepared to report out on that next month. And also, I should mention, I don't want to be cryptic, we are absolutely working with Brunswick Materials to seek compliance, and in fact, they've applied for a special use permit to amend that condition to allow the gate to be closed from dusk to dawn. And so we will have more information, but at this point, the ranger has gone out there enough times to, recently, and found the gate closed, therefore precluding public access, that's a violation of the SUP. So we want to start the process and conduct the investigation.
Having lived here for a long time too, I was out there and hadn't been out that way for quite a while, and it mentioned that 3 miles past the facility, that it was closed. But right there where he is, it used to be Hodges was there, I believe. You could take that bridge across, and we went Christmas tree hunting and everything else back in that area back in the past. But basically, the only area open is just beyond that now, I guess, for.
Right, the bridge is blocked off. I did see that when I was out there. I don't know when that happened or why that happened, but indeed it's blocked off. And also, I was just going to tell you something. Oh, yes. Once we start the investigation per the code, and actually our next item, we're going to talk a lot about due process. So that's why this is really important, this due process. So the first part of this 4-step process is the commission requests that the director conducts an investigation. We then have to notify the business owner that we're conducting this investigation. And we then conduct the investigation, we'll talk to the business owner, and again, we are already in communication with the business owner, and I'd like to be very optimistic that we're going to be able to resolve this, but on the other hand, I want to look out for this condition, so I'd like you to request an investigation.
Commissioner Preston?
Yeah, I just wanted to go on record on some of this stuff, is that I actually sat on Open Space Committee when we actually bought the 800 acres and spent several millions of dollars out of Q18 money for this, that were actually paid for by the taxpayers. And so one of my big hot buttons has always been able to have access into that canyon, coupled with the fact that also, my significant other was part of what they lovingly called CRAC, which was the Carson River Advisory Committee, and was instrumental in getting the water trail, the aquatic trail put in. And it has always been a concern of mine, even when the V&T was in there, is for safety reasons that this is an area where people do recreate, and they don't recreate where they just walk. There's motorized vehicles, there's rafts, there's waters, there's all sorts of hazardous things that are going on. Plus, that canyon is so darn tight that the access to me is very imperative. So I really want to put that on the record. In addition to that is that that gate did show up after the purchase of open space. And I do know that they actually were working with Juan Guzman on that particular thing because the previous owner did lock that gate. So that's a problem. The other thing that I'd like to bring up on this is that road, I feel very strongly is part of the accessory roads that is protected by the state of Nevada, not unlike Ash Canyon. And that currently, because of that boundary that is on the east corner where it's adjacent to the river, up to the bend where how it goes up to the old sap mill, is continuing to erode. I would like to ask that when the director investigates this, whether or not they consider, especially if the guy is going for an additional special use permit, to figure if that road could be widened or that fence could be amended so that people can get around there safely. So, thank you.
Any other questions for staff? Since the applicant's not here, I'm asked for public comment, I would think.
Well, I'd like to.
Oh. Okay. Could you come forward, please? Thank you. I didn't know if we had to just bring it under public comment or whether she would be part of the process.
Hi, Commissioner Doors for the record. I feel like this was more for you, but it might be staff questions. I just didn't want to have to ask it twice. The dusk till dawn, that's all over. There's signage up there when you go out now. I just went out yesterday or 2 days ago whenever I picked up the packet as well. Did we put the signs up or is the dusk till dawn on the Carson City open space sign when you're past the business in question? It seems like that's a Carson City sign that says dusk till dawn too. Then there's signs leaving that are attached to the fence that no one knows who put there. And is that are any of these our rules or are these the company's rules?
Thank you, Commissioner. Jennifer Budge, Parks and Recreation Director. There's a myriad of signs out there. It is confusing. A lot of them have been put up, we think, by the property owner, and some by the Open Space Division for Parks and Recreation. So there definitely needs to be a coordinated effort on that as well, and I think this will assist in a conversation about that to making good, clear messages to the public. But typically, our park system, we have over 9,000 acres here in Carson City, is typically available to the public, from dawn till dusk, which is typical. We do have exceptions to that, especially facilities where there's special events and we allow late night activities. But that is our typical rule of thumb that's in the municipal code.
In that area out there, Jennifer, do you enforce the dusk till dawn or the parks? People go out and check to make sure no one's in there, whatever?
We do have 2 full-time park rangers and we have a seasonal park ranger that, as best they can, goes and patrols our entire park system. They do go through there as often as possible and then clears the canyon, around that time that the sun's going down. Because if they are there after hours, it's typically not for a good activity. So we do try to deter people from getting back there. And it's difficult to see at night if you're way back in the canyon, just getting out. We've had issues of vehicles going over the cliff and into the river, and we've had, some emergencies. So we want to make sure that access is cleared. So we do send our park rangers in there on a pretty regular basis.
So through this process, eventually it might be to the point they may want to utilize that gate to keep access late at night or whatever, or something, possibly.
Yeah, and we are open to those conversations with the owner and would like to work cooperatively with them. But we have had at least 14 instances since October that we've documented with the gate closed. And some of those days have been on the weekends, and we receive numerous complaints from the public, especially on a Monday after they've wanted to go out and recreate, whether on a motorized vehicle, whether rafting, a variety of access. And, access to our public lands is very important, not only to our department, but Carson City residents. So we want to make sure that they have every opportunity to do so.
And unfortunately, in most cases, I'm sure they don't know who's locking that gate, but you're the one that gets the call, I'm sure, every
Exactly.
time. Any other questions for Jennifer? Thank you.
Thank you.
Mr. Chair, if I could just make a comment.
Certainly.
Ben Johnson, Deputy District Attorney for the record. I just wanted to add on to what Ms. Budge said, that the city is hopeful that the SUP holder is willing to work with us. However, some of the closures that have happened have occurred after the owner has been placed on notice. And so we just want you to be prepared that, to go towards revocation if necessary. We hope it doesn't get there. However, this is the process, as Hope said, gearing you up towards that. Thank you.
Bringing it back, I'm prepared to make a motion.
I have one more question.
okay.
Just to clarify, the special use permit itself that, is in question here, it looks like, the way it reads on here, it's that basically to run that entire business is what the special use permit is. So if we do end up down the road revoking, they're out of business essentially at that location. Got it.
So I move to request that the Community Development Director investigate the conduct of Brunswick Canyon Materials LLC relative to special use permit U-79-25. You have a second from Commissioner Eschwein. All in favor? Aye. Opposed? None? Okay, moving on. E5, ZCA-19-048 for discussion only. Discussion regarding Nevada Revised Statute 278 and Carson City Municipal Code Chapter 18.02, administrative provisions. Hope?
Yeah, I'm gonna start. For the record, Lee Plemmel, Community Development Director. So we're kicking off this discussion about Title 18, and just to remind you and anybody else watching, we're going to, over the next probably year and next 2 years probably, be updating Title 18. So for any members of the public and you, as we walk through this, if there's any suggestions to Title 18, we're going to be collecting things. So we're kicking it off tonight with a little bit of background on zoning in Carson City and the administrative provisions of Title 18. So I just wanted to start out a little bit. I'm going to talk about NRS just very briefly with a couple slides, and then turn it over to Hope to start walking through Title 18 and the administration of it. So Nevada is a Dillon's rule state, which means that as opposed to a home rule state where the states don't have to get authorization from, or I'm sorry, local jurisdictions don't have to get authorization from the state for regulations. And a Dillon's rule narrowly defines the power of local government. In other words, we can only adopt regulations that the state authorizes us to adopt. For example, and NRS 278 is the planning and zoning section of NRS of state law that allows us to adopt zoning and planning regulations, and it's pretty broad in those. It establishes the planning commission, creates the authority of planning commissions, It establishes the procedures and contents for master plans and how to adopt them and amend them. It establishes the procedures for adopting zoning and the way to amend those. NRS also, and so broadly under those regulations, that's kind of the processes that we use and bring forward to you. NRS 278 also contains some specific things like especially regarding certain uses, like some examples like for solar energy, ham radios, amateur radio antennas, factory-built housing, group homes, and other uses often have very specific provisions in there, usually limiting local government's ability to provide regulations for those types of uses and zoning. And every other year when the legislature's here, there's always some legislation regarding that. Just a couple, just for your information, that are there this year. There's a small cell wireless bill that would basically take away the local government's authority to regulate small cell wireless on the cable that are attached to the cable provider lines across utility poles, and that bill's still going forward. And there was also a bill another one was to treat nonprofit organizations differently in zoning. Without going into detail of that, they thought they shouldn't have to be regulated for certain things because they're nonprofits, and that bill died. But there's bills every 2 years here to try to change what we're allowed to do in terms of zoning. Next one, please. NRS also authorizes specifically, so there's this specific section on special exemptions, which is the special use permits and variances that you grant, and it gives the local government's authority to grant that power to the Planning Commission, which the Carson City Board of Supervisors has done. So you have final decision authority on special use permits and variances, so that's specifically authorized in there. This chapter of NRS also has procedures for all the types of divisions of land that we have, subdivision maps, parcel maps and things, and those are addressed in Title 17. I'm sure we'll be moving on to that through this process as well, but right now we're still focused on Title 18. And also know that even for planned unit developments, there's a separate chapter, which is 278A, and that has all the things to do with planned unit developments. The Division of State Lands is nice enough to put together a book every 2 years that are the laws, the state laws related to planning. So these are all the laws related to planning. And it's about, and this much of it is about NRS 278, but there's all sorts of laws related to planning. So this is our handy reference guide all in one place. And I think that's all I wanted to cover, just a little bit of background. Any questions on NRS before Hope gets into it?
Okay, I'm going to talk about Chapter 1802. Everybody sees me walking around with this big beat-up book, right? It's because of the procedural due process. 1802 it talks about the administration of the zoning ordinance. It's basically, it's essentially the foundation of the zoning ordinance. It tells us what our tools are, who the players are, what our processes are. You'll hear about due process. There's two types of due process, right? There's procedural due process and substantive due process. This is our procedural due process. If we mess up on this, we can't, it doesn't work. We can't mess up. You can't have a meeting. You can't take an action if we don't follow this due process that's outlined in 1802. So we're constantly pouring through this book, figuring out, okay, on this process, procedurally, what are our requirements, and so on and so forth. These are 1802, and I hope you all had a chance to read it. Those are the administrative provisions of the zoning ordinance. It's not telling you what your zoning districts are. It's not telling you what your land use districts are. It's telling you all your administrative stuff. So who are our players? Our players are kind of obvious. The Board of Supervisors, and Lee just kind of outlined how NRS identifies what the role is of our board. Our board has 3 responsibilities per Title 18. They can divide the city into zoning districts, which regulate the use of buildings, structures, and land. That's basically zoning, right? They can adopt a master plan to guide growth and development, and they can identify regulations related to the subdivision of land. So the board is the one who makes the rules. You all have certain things assigned to you, and you're often in a position where you're making recommendations to the board. And that's all part of the procedural due process that's outlined in 1802, and we're going to get into that. In 1802, it talks about the Planning Commission. It talks about the membership of the Planning Commission, that we have to have records of your meeting. That's why Tamar's here every single time, and every single time you're voting on your minutes. You're required to do that per 1802. In any decision you make, and again, as Lee said, you're authorized to issue a special use permit, you're authorized to grant a variance. Any decision where you're the final decision may be appealed to the Board of Supervisors. That process is outlined in 1802. And the staff has a role, and we're going to talk a little bit about the hearings officer in a little bit. That's the community development director, is the hearings officer. So throughout the code, we'll read about the director. We just talked about, we asked you to request that the director, so on and so forth. The code typically will use the word director. The director may delegate that responsibility. It's still the director. I want to talk about Planning Commission just real quick. And this is not in 1802, but this is pretty typical. The Planning Commission's a cross-section of the community. So I know sometimes when you're looking at the findings, some of you get frustrated and you say, but this isn't objective. I need an objective measure. This is so subjective. It is subjective. That's why it's yours and not ours. If it wasn't subjective, it would be what's called a ministerial permit, and we would be able to say yes or no, and staff could handle that. The board has identified in creating the rules those things that are called discretionary permits, which means there's discretion. It might be okay. And that when we have those, we have findings of fact. And the Planning Commission, as a cross-section of the community, reviews those findings, and you're sort of the barometer, if you will, of the community. You establish the value system with respect to land use. Granted, your decisions may be appealed, but you don't need to be experts on subject. You're an expert on being a resident and a business person here in Carson City. And your judgment is what's necessary to make those findings. The purpose statement of 1802, I think, is really important. It's only 4 items. It's what you do all the time. And so hopefully, as I say this, you're like, yeah, we do this all the time, because you do it all the time. The purpose of 1802 is to implement the master plan. You'll often, when we look at the findings, we'll say, is this consistent with the master plan? And we all have to respond to that and make a determination if there's consistency with the master plan. The zoning ordinance is one of our primary tools to implement the master plan. Number 2, the purpose statement says we're establishing a comprehensive, consistent, and equitable regulations, standards, and procedures. That goes right to our procedural due process. Anyone who asks for an SUP is subject to the exact same process. And so we have uniformity in processes. There's expectations of what the process will be. It's not ambiguous. It's very well spelled out in 1802. The purpose of the zoning ordinance is also to implement process-oriented standards, so again, more procedural due process, and to implement design-oriented standards. So when we get to 1805 and when we get to the development standards, we'll be looking at design-oriented standards that are all part of our zoning ordinance. Again, because this is the administrative piece of the zoning ordinance, there's a lot of due process stuff. It talks about the administration, jurisdiction, interpretation, application, enforcement, noticing requirements. It talks about the hearings examiner, which I'll talk about in just a second. And it talks about fees and service charges. So that's all outlined. And we have to make sure we read the code every single time we get an application, that we're following the process of the code as outlined in 1802. What you may not know, and because it doesn't affect the Planning Commission, but there are certain things that are assigned to the hearings officer. There's what's called an administrative permit. An administrative permit is subject to the same 7 findings as a special use permit, but the hearings officer, which is either the community development director or the planning manager, can conduct the hearing. But we conduct a hearing just like you conduct your hearing. We listen to the staff report, we listen to the applicant, we invite the public to make testimony, it's taped, it's a public meeting. So we have those meetings. We don't have them frequently, but we do have those meetings as well. Planners often talk about the tools in their toolkit. So these are the different tools that we have available to us in Carson City to implement the zoning ordinance. They're in alphabetical order. You've seen most of these. Appeals. You had an appeal of the staff decision regarding a fence over on Ponderosa in some containers that were potentially buildings. Your decisions can be appealed to the Board of Supervisors. That's all in 1802. 1802 identifies who gets to appeal, whose decision, and what the appeal process is. The abandonment of an easement, only the Board of, an easement can sort of be two things. It can be an easement, in which case it's administrative, or it could be abandonment of a right-of-way. Only the Board of Supervisors can abandon a right-of-way, but the Planning Commission conducts the public hearing and makes the recommendation to the board. And you've done a bunch of those. The master plan. Only the Board of Supervisors can amend the master plan. The Planning Commission reviews the request, and you have findings of fact, and you make a recommendation. Again, you're a cross-section of the community, so you're conducting the public hearing, you're reviewing the findings, you're making the recommendation. The same with zoning map and zoning code amendments. Only the Board of Supervisors can amend the zoning map. Only the Board of Supervisors can amend the zoning code. But the Planning Commission is charged with conducting a public hearing, looking at the required findings, which are in 1802, and making a recommendation to the board. Special use permit, the board has assigned that to the Planning Commission, so you're authorized to issue a special use permit upon making the 7 required findings. The variance the same. I believe there's 3 required findings for variance, and the Planning Commission has that authority. Major project review it's kind of a different animal. It's almost like a pre-application, but there are certain things that are required to be subject to major project review. The staff conducts the major project reviews. The administrative permits is the hearings officer can issue the administrative permits, so you never see those. And a temporary use permit, the community development director can issue that, so the Planning Commission would not see that unless there's an appeal. Also in 1802, they give us standard conditions of approval. So when you see our staff reports and you see the conditions of approval, very often the first 5 or so are, you see them every single time and they're the exact same wording. That's coming right out of our code. When we have, I know with vintage, what I did on that one was, which that was a little bit of a different animal, I called out that that was coming right from the code. Because everything was being so contested, I wanted them to know which ones were from the code and which ones were being staff recommended. But when you read 1802, you'll see for each of these tools, there are standard conditions of approval that the board in creating the zoning ordinance has requested that we assign to every single approval. And so that's 1802. So this is the administration of 1802. That was hopefully pretty brief, but we felt like it was important for you all to have a chance to read the ordinance before we started sort of looking at it more critically. And I guess I'm happy to answer any questions you have.
Let me add a little bit to that. She got me thinking about something I actually had written down to talk about a little later, but in the uniformity of processes that are established in here, and she mentioned due process and equal protection, and actually those are real important things at this planning commission level. Due process and equal protection under the Constitution, there's actually a lot of case law for applications related to that, where there's lawsuits against cities and things related to due process and equal protection. And so the reason I bring that up is because as you've been assigned for the final decision on special use permits and variances, you're acting in a quasi-judicial capacity, as opposed to the Board of Supervisors, who are a legislative body. So, people they get lobbied to get, the code written that the way people like, and they have that authority. They're a legislative body, but as a quasi-judicial body, and not only with the special use permit, but you are, as she said, you are the public hearing body for the items that come to you for a recommendation, and though this is where the public hearing is conducted. So in your quasi-judicial capacity, you really have the duty to conduct a fair hearing here. And meaning, you should not, gets to our ex parte communications with others, you should not be discussing the case with one party on one side, at least without disclosing it. I mean, you can have contact with them and, disclose during the meeting. So I'm not going to go into the details of training on that right now. But generally speaking, this is why we don't give out your home phone numbers to the applicants and everybody. Hey, I want to call everybody and tell them why my project's so great or things. We try to buffer you from that because you're not the body. They can go lobby the Board of Supervisors on it, but we do try to keep everybody from coming to lobby you, and that's because, you should also be thinking as people approach you, is if there's information that you think everybody should have, then everybody should have it for that hearing, so everybody has the same information. So I wasn't really kind of prepared to give training on that, but it might coming across okay. But I wanted to point that out.
And now he just made me think. Okay, so just to re-emphasize the concept of a quasi-judicial public hearing versus a legislative public hearing, and this is not the case in Nevada, but I've worked in North Carolina. In North Carolina, as a staff member, if it was a quasi-judicial public hearing, I was sworn in before I gave my staff report. It's testimony. It's serious. It's quasi-judicial. Everyone is sworn in before they testify. It's testimony. A legislative public hearing, you are not sworn in. So in a state like North Carolina, it's very clear to understand the distinction because the process actually shows it's a different process if it's legislative versus quasi-judicial. But your hearings, definitely the special use permit and the variance are absolutely quasi-judicial. Legislative tends to be policy items. The other thing I just want to mention, and then I'll stop, is I just want to talk a tiny bit more about the staff's role with respect to the Planning Commission. Because Lee talked about, getting information outside the hearing. And I know some of you have called me and said, am I allowed to talk to you about this? And once my staff report goes out, my job, if this is something that's coming before you, is, and all of our jobs, is to make sure that you have the information you need to make your decisions. I'm not lobbying. If I have a conflict of interest, I'm not involved, okay? My goal is to make sure you understand the regulations, you understand the master plan, and you understand everything that applies to that application, and that you have what you need to make a decision. So if you're ever coming into a meeting and you're like, well, gosh, I just don't understand this or whatever, a lot of you do this, feel free to pick up the phone and say, I'm not understanding this. The chair called and said, we're talking about that gate out by Deer Run, right? And oh yeah, it didn't occur to me, maybe I was looking at a different gate, but yeah, thank you for calling. So don't ever think that staff's not available to support you, because that's what our job is.
It's kind of ironic, too, that one of the few cases we had where I was contacted was the gentleman that did the special use permit for the sculpture we talked about earlier. It was on the planning department when that was approved. He was one that was representing somebody here that I know had contacted several of us and we had to state that during the meeting that we had been contacted, but.
Okay, now what?
Yeah, I was going to give the update, but as this relates to Title 18, where do we go from here? As I'm going to update in my staff report on the next item, we have a big May agenda. So I don't think we're going to tackle another section of Title 18, but we're thinking at this point, it's going to be as applications, as regular workload allows, is to start scheduling workshops in between regular meetings. Perhaps if we do have a light agenda using a planning commission date, that would be great, but scheduling workshops in between, which at this point won't be before the next planning commission meeting. And with perhaps just moving through, we have the definitions, but probably Title IV and uses as we're putting together tables to look at that might be the next place to start, to kind of look at uses in zoning districts.
And you are obviously the development director, correct? That is one part of your duties?
As used in the code, that's, yeah.
Yes, okay. One other, has this been changed, morphed, or whatever? Because I noticed I had pulled out from the 17-18 that we received from 2013. And I read through 1805, and just was looking at it, but this is kind of, and the info seems the same, but it's printed a little different. I don't know. Is there? Well, no, this just had the official 18049 BOS 713 of 14 and all that. I'm sorry.
Well, that's okay. We were just talking about what you got. Okay, so basically what happens, and this is probably too much information, but on the internet is the municipal code. There are certain sections that are not codified because they just haven't had a chance to codify. So the board has taken an action, they passed an ordinance, they've amended the code. But if you go to the codified code, that amendment's not there. You have to go to this extra piece of paper. So for our benefit, and now for your benefit, Shelby in our office, she keeps a Word document for us so that we're always carrying the current code. We don't have uncodified stuff to carry around, so you have the current code.
This is the one we should be looking at and reviewing.
The one that she put in the binder is the current code that has all uncodified amendments incorporated into the Word document.
And as I say, I just happened to go through and I had highlighted in the others, so I said I'll highlight in this, and there was very few, but there was a couple that something was different, wasn't there or whatever, that's all. Just curious, thank you. Other questions for
Yes,
staff?
I have some.
Commissioner Borders?
In the process moving forward, when and where do you want all the minutia that we've raked up? You want it now?
I would like it now. I know even as I was reading it, I was reading things, and I was marking my agendas. I was literally writing in my book, because I was
Well-
finding stuff in 1802 as I read it.
Let me give you some examples and see if that's what you're looking at. In section 1802.10, paragraph 3, it talks about the appointment of the members. Now, the Board of Supervisors has changed it. We're not all at large anymore, I don't think. And should that not be reflected?
Still would be at large, just we're selected by a board member or whatever.
Well, but it's
and
not
brought forward.
referenced in
Right,
here.
Right,
Okay?
Okay, got it.
Section 02.012,
Well, this is mine. This isn't necessarily.
it
I'm
talks
sorry,
about
can you say the section one more time?
012.
012, okay.
The caption is Commission Actions Appeal to the Board and Attendance of the Director. The Director is not defined until 1202.020. You need to define him before you tell him when he has to be there.
Director's defined in definitions too.
Well, there are no definitions in here, that's in the front of it.
Not in the front, but they're in there, they're in.
Yeah, but the first time you read it is in .012. All right, what's the Director? There's nothing in front of it. There is
Noted.
behind it.
so is that sort of thing
Is
us,
that-
or
that's-
is that
that's
gonna
my
be
question.
cleaned
Is
up by our lawyer, et cetera, that he's gonna be going through to clean it
Well,
all
and
up?
that's the question. Are they gonna do it by themselves or do they want an input from us?
I think your comments are helpful, and they are along the lines of things I was scribbling in the margin. I think what we can do, given the nature of it, I think there's two things. There's one, what you're getting to is sort of the structure, which I think is helpful information. If I could get that from you in writing, or we could sit down real quick, just one-on-one. The other is sort of the more substantive, and let's just take or the accessory dwellings, for example. When we get to that section, I suspect there will be a lot of discussion about the substance of the regulations, and if those are still reflective of the community, and if there's recommendations for a different approach. So if that makes sense, if it's more stylistic formatting, structure, if we do that one-on-one as you guys see things, and then if it's sort of big, more substantive, we have it as a discussion item.
Or for example, on the sign ordinance, that we would, does it have to come forward every 5 years? Or if people are checking them, if there's a problem, they would bring it forward immediately, or, that's, we have to, look at that sort of thing as well. But again, probably in a format like he's doing, go to 1802.007 and make a comment. So at least there's direction for you folks as to where we're going and pulling it from.
Right, for just an easy example of something I identified, in 1802, it says the applicant has 25 days from the date of receipt or the date of action or something to sign the notice of decision. Yet the condition of approval says the applicant must return the signed notice of decision within 10 days. well, is it going to be the 25 or the 10? So we should, I mean, that's not something for a big discussion. It should just get reconciled. So I'm looking at the same level you're looking at, Commissioner Borders.
Well, then I guess the only substantive thing I have is back in the back where we talk about hearings. And we've had some discussion about this previous, about putting some sort of a limit on when we get material for us to consider.
Oh, you're referring to the late material thing?
late
where it
materials,
comes in, we
yeah.
get 40 pages when we walk into the
Yeah,
meeting.
there's a place under
Which isn't a
hearings.
staff problem, it's because they aren't sending it in time to get it, you know.
No, I'm not saying that, but if we want to try and do something like, put a deadline on that communication before it gets to our packet, or make a determination about petitions. You know, there's a section in here for special use permits for hearings, for variances for hearings, you know, and the words are pretty much the same. One of the things we as a board talked about was whether or not we wanted to try and write something about when we got late material and what was the deadline. You know, is it 5 minutes before the meeting, or is it 2 days, or whatever it is? And I don't think we care. I just think we need to try and figure that out.
When I brought that up, I suggested maybe like at the end of work on Monday, if it's not to you by then we're, you know, not that we won't look at it, we may not have time to consider it or whatever, you know, something to clarify that, so we aren't working in the dark.
You preempted another point I was going to have later. You asked that question. So we do in our current property owner notices, let them know that they need to get it to us by a certain date if they want us to get it to you in enough time to actually read it before the meeting. To your point, that's what we can do for now. To your point, I think we need to, when we're going through the code, we'll look at that. But again, we'll also have to get with the DA's office on equal due process and equal protection issues of, I suspect people are going to be able to show up at the meeting and give you stuff, but we'll look into that.
Okay. I'll give you the rest of this in writing.
Other comments or questions or anyone?
Well, I was just going to follow up with what Lee said about, you know, if you're going to have a public hearing, then you have to accept that people are going to come at all periods of time before and up to when you make your decision to give you information. You can't, I don't think you can limit when they're going to.
Well, that's why I worded it, not that we wouldn't consider it or we wouldn't accept it, it just may not be enough time to give it its fair value or whatever.
Well, that's like saying that you're not giving the public who comes up in front of you the benefit.
Anything else?
What item are we on?
We're still on that same item.
Okay. Good no.
Well, staff for that very much.
For the record, to my fellow commissioner's point, the definitions, I did find them and that's how I knew, I actually looked up director in the definitions to find them, but it was kind of confusing in going through. I had to kind of go back and say, well, where are the definitions? And they were after, and I know what I just looked up was just a random NRS, and that's kind of how they're structured, but there's a lot less information before the definitions in the NRS than there is in the Title 18, so it might be worth putting the definitions up front.
And
And actually, the comments you're making are excellent, because the mayor in particular has specifically said he wants this to be rewritten so the man on the street can pick it up and understand it. So we work with it so much, sometimes we can't see it. So your comments are awesome. Thank you.
Well, what's interesting too is that you brought up who the director is. You had it written, and I looked it up too. So we all kind of pinpointed on director as a key term, I guess, making sure it was Lee.
I figured it was the head person down there, yeah. Head person. So under ZCA 19-048, it was for discussion only, but I will ask for public comment. Seeing none. Under staff reports.
Yeah, I just want to quickly report on prior planning commission items that went to the Board of Supervisors in April. The RV park special use permit for the extended stay, 180-day stay appeal went. The approval of the planning commission was upheld. There was a modification of conditions. Specifically, there was a lot of discussion regarding the time frame. Now, they left it at the 180 days, as was discussed. I told them at this planning commission discussed possibly a less day, but they left it at 180 days, but included a condition about having to leave the park for 30 days. And we mixed in some verbiage in there so it can't be gamed and they leave the day before and then come back the day after. But so that the intent is that stay and then they have to leave for 30 days before they can come back and start their extended stay over again. But other than that, it was upheld.
Like during our discussion when they couldn't just move from one spot to
Right,
across
right.
the
So,
street.
right, it was an attempt to address that.
Question, though, who's going to enforce that? How is it going to be enforced? Is it self-enforcement, or is it, how's that going to work?
Well, I don't remember if they had to provide any documents to the tenants, but no, I think, and I'm thinking about it, if this is we have a lot of them, that are grandfathered anyway, where there aren't time limits, so that's not an issue. But knowing this is a big deal, and this is, we haven't had these in a long time, it's not like we've had a lot recently, so this is something that code enforcement can go out and request records of and do spot checks. So I would anticipate, should this get developed, that we would start that right away. And then secondly, going last month to the Board of Supervisors, they approved the Blackstone Lampa Ranch tentative subdivision map condition modification related to the drainage that went through as well. And just in terms of applications for next month, we have 8 to 10, depending on how many we decide to get on there. We have a couple of our own zoning map amendments, but we have we have a special use permit at Eagle Valley Middle School storage container and abandonment on Robinson, off Salomon Road near Robinson. Special use permit, 2 special use permits for childcare and 1 for adult daycare. Tentative subdivision map for the Railroad Drive area. That was the one that came for the zoning map recently. An amendment to the special use permit for the Brunswick Canyon, so part of addressing this issue, not the closure specifically, but to partly address that issue, they're coming back for an amendment. We have a couple zoning map amendments that were identified and a master plan amendment that were identified in the last master plan report that we will be bringing forward in the next meeting, if not then June. And with all of those, I'm going to push the growth management item to June. That'd be June 26th. By the ordinance, it goes to the Board of Supervisors, second meeting in July anyway, so we still have time, but we'll see what we get in June. Hopefully we have a little bit more time in June for some discussion on that item and maybe Title 18 stuff.
So you're saying we may be here more than an hour and 15 minutes next month?
Next month's probably more than an hour, yeah.
Lee, is that the amendment to the special use permit for Brunswick Canyon, is that what you were referencing earlier about them applying to be able to close it? As well as we'll also hear about the results of the investigation separately. Okay, thank you.
Okay, Eddie, we have any commissioner reports or comments? Commissioner Tingle.
Yes, there are 2 requests that I would like to make for future board or future commission meetings related to having a presentation done by both the Carson Tahoe Health and Carson City School District about what their plans are to support the increased population that Carson City is likely to be realizing based on all of the approved development that we have recently seen. I have an instance that highlighted the lack of medical care in this community, especially on an emergent basis, that I feel needs to be addressed. And I feel very strongly about the Carson City School District and the Carson Tahoe Health not coming to these meetings or presenting some factual basis for the memos that they provide about how there is no impact to their services as a result of any proposed development. So I am asking that at some point, we request their presence to give us some idea or indication of how they are going to address this issue as far as healthcare and issue as far as overcrowding in the schools. So,
As far as the hospital goes, we could ask them to come. They're a private entity. I think that's up to them if they're going to come or not. But I imagine with the school board, we might be able to have a little different scenario. But again, we can request that.
Can we as a body request, especially I got the green light.
I saw.
Can we as a body request, especially from the school board, at least a presentation, if not like a case-by-case appearance and individual, but can we request like a presentation on what their 5 or 10-year plan is or whatever their plans are?
They actually gave us a presentation back with the Lampa facility, I think it was, where they came and went through as far as what pressure would put on the middle schools and what was going to happen.
I mean, less
They have a-
specific.
They have a group that meets, bi-monthly, that Hope and I are on, where they typically every 2 months go through the population and they look at everything that the city has supplied
So can we
to come up with that.
Can we request their presence on a general basis to show up and give the commission a presentation? Less about Lampa or a specific development, but Carson as a whole.
Or maybe Commissioner Borders and Hope could give us no? It's just an actual meeting you attend?
Actually, I only substitute in, but but I always sit with Chuck when I go. And actually, they have, the schools, can you invite the school to come and give you a presentation? 100% you can invite them. Will they be available? I don't know. We can't speak for them, right? But they are doing a lot of demographic analysis, and they've made presentations. They're using outside consultants to try to project what their school demands will be at various cohort levels. And I think it was a really interesting presentation, I thought, and Chuck and I both saw it.
And it ties in with growth management, so, and with May being full, I think we'll target June for that, to ask them to be here. Which I did last year, ask Carson Tahoe Hospital to attend, and they didn't, and
Commissioner?
Yeah, I have a question, and I don't even know how to even phrase this, is that I do know that, there's a lot of different projects that have been out in the works for a long time that have been given authorization. And I mean, I've had people come to me and say, how many years has that been out there? And I know that those are things that we need to factor into the growth management, but if you have a developer that's not doing anything, can you kind of let us know where we are on growth management on some of these divisions as to how long they have been perpetuating? If that's okay, thanks.
you mean, how long have approvals have been out there?
Yeah.
Okay.
Sorry, I came back in here in 2005, and I keep seeing the same dirt getting moved, but I'm not seeing some of these things being done. And people have asked me, they said, what is the story on this project? And I know we had the economic downturn, and I know that, we've had different developers take over different projects, but it would be nice to know where some of these things really truly are.
We've been doing that with growth management, which has usually been in May in the past, but will be in June this year.
We call that the Ormsby House philosophy. I couldn't resist that. I think the bank club will be open long before that one.
I do have one more comment to make related to the access to healthcare issues, and I do participate in the Community Health Improvement Plan through Carson City Health and Human Services. But when we are reviewing these requests for special use permits or planned unit developments or any new development, and we are looking at an impact to the population of this community where the access to healthcare is already stressed beyond the point where they can support the current population. Are we remiss in not addressing that issue when somebody has brought a request for a new development? Are we not responsible to say, hold the phone, we don't have the capacity right now to support the community that we have, and now we are looking at bringing more people in or adding additional stress on an already stressed service? Because, and I've worked in the health field since I retired from the state, which is 2008, and I've seen it degrade year after year after year. And I just feel that we have some sort of responsibility to the members of this community to realistically look at that issue. And if we don't, then I think we are doing a disservice to the current population of this community, let alone anybody else coming in. And that's just my feeling about it. I feel very strongly about it, and I don't know if you can tell.
Yeah, and I've been involved with the healthcare, because I'm working at the hospital, et cetera, since '76 and still in the facilities today. But as long as they're telling us we have enough water and that we have enough schools and we have enough healthcare, let's us to make the determination. So I understand where you're coming from now.
Can I change the subject? When we do this review of Title 18, would it not be better to adjourn to a workshop? At the end of the,
I
at the
think
end of the
we're-
meeting, just adjourn to a workshop so that we can discuss it? Because there's no action to be taken anyway. And it leaves us a little freer.
Okay. We can talk to Ben about formatting wise how that would work, and I think if we can accommodate that, I don't see why not.
Okay.
And I think now, like you have done, and if we all do that, go through and make our notes and that sort of thing and come up with lists, now that we have a direction as to how they kind of like us to go, I think that would work.
Do we want to do it
Just sufficiently.
via email, or do we want to do it?
I think we'd each go through and give our thoughts or whatever in reference to what our thoughts are and give them to staff, and then they can pass them through Ben and the others and work them in or answer whatever they see, so.
And I think Lee said this, but the idea is, right now, we're familiarizing you with Title 18. You'll be conducting public hearings, but we want to make sure you understand the document before you do that.
Okay.
I'd like to suggest that if members of the commission have ideas or issues with specific areas of the code, that they forward them to staff, and that staff then provide all the other members with those comments so that we can ruminate on them before the meeting.
Okay, one more time. Is there any public comment at this time? Seeing none,
Mr. Chairman, I move we adjourn.
take a motion for adjournment. Second. All in favor, aye, aye. Thank you.